Just give me the bullet points.
Exactly.
Keep it easy on me.
Please. You call everyone to order, please. Sound engineer. Test, that's it, thanks. So we're on the record at 9 o'clock. Good morning, my name is James McClymans. I'm the Chief Administrative Law Judge with the Office of Hearings and Mediation Services, New York State Department of Environmental Conservation, and the presiding Administrative Law Judge for the adjudicatory hearings being conducted on the application of Finger Lakes LPG Storage, LLC, for permits to construct and operate a new underground liquefied petroleum gas, or LPG, storage facility proposed to be located in the town of Reading, Schuyler County. This morning, we are continuing an issues conference pursuant to section 624.4B of Title VI of the official compilation of codes, rules, and regulations of the state of New York, or 6 NYCRR. For the record, this issues conference is being held on Friday, February 13, 2015, at the Holiday Inn Express, 2666 Corning Road, Horse Heads, New York. And now I'd like to take appearances of counsel, starting with department staff.
Your Honor, Lisa Schwartz, Assistant Regional Attorney for Region 8 for department staff, along with John Maglianti and Larry Weintraub from Office of General Counsel of Federal.
Thank you. And for Finger Lakes LPG Storage, LLC?
Kevin Bernstein, Brian Seneca King for the applicant.
Robert Alessi, DLA Piper for the applicant.
Brent Bacon on the applicant.
And for gas-free Seneca?
Deborah Goldberg and Nanine Naismith from Earth Justice.
And for the Seneca Lake Pure Waters Association? And for the Seneca Lake Communities?
Good morning, Your Honor. Kate Sinton, Dan Rochelle, and John Croix with NREC.
And for the Finger Lakes Wine Business Coalition?
Good morning, Your Honor. Meg Tor and John Barone, Tor and Barone.
And for Schuyler County legislators Harp and Lozelle?
Yes. Michael Losell and Ben Hope.
For the National Propane Gas Association?
Good morning, Your Honor. Jeffrey Petrak.
And for the New York LP Gas Association, Inc., and the Propane Gas Association of New England.
Good morning, Your Honor. Matt Friedberg.
And for United Steel, Paper and Forestry, Rubber, Manufacturing, Energy, Allied Industrial and Service Workers International Union, AFL-CIO, CLC. All right, so now I received an email from Catherine Shaw ceding her time to the applicant for this afternoon's session on public need and benefit. Let me get some clarification as to what precisely that means. Will the applicant be representing the United Steelworkers or defending its petition for party status?
No, Your Honor, we will not. We will be doing the same things as the parties did yesterday when time was ceded on an issue to another party. We will be speaking about the topic just as that occurred yesterday.
Okay, well, the reason I hadn't originally scheduled time for the applicant on the issue is because I didn't see that you opposed the petitions, the three petitions of the gas associations and the United Steelworkers. So
Well,
the only party that opposed the petitions was staff, who in their letter had indicated that they were taking a position no party raised any trouble or substantive significant issues. So would you be representing the petition, or you simply want to be heard on the question of need?
Both, Your Honor, in terms of two reasons. Again, Yesterday, in terms of what happened, people spoke to the subject matter. So we would be presenting a position in support of the petition and to address some procedural issues to address the overall issue of the regulations and whether you need to have something wrong with a project to be able to come in and be in amicus in a proceeding. So that's one we would address, and two, we would address the substance of the particular topic.
So you will be defending the petition of the United Steelworkers. That was my main question.
You will be defending the subject matter of the petition, yes.
All right. Is there any objection to this?
I guess not.
All right. All right. All right. Very good. So are there any other preliminary matters anybody wants to raise before we get started? No? All right, then let's begin on a noise issue and gas-free Seneca, which is scheduled to begin. Am I wrong about that? Hold on a minute. So I have you down for 15 minutes.
Yes, and if I could reserve 5 minutes for rebuttal, please. Good morning, Your Honor. Gas-free Seneca retains Sandstone Environmental Associates to monitor noise in the project area and to evaluate the noise study prepared for the applicant by Hunt engineers, architects, and land surveyors. Sandstone presented numerous criticisms of this noise study, which the applicant attempted to rebut in response to our petition and in a memorandum from Hunt. Sandstone's criticisms and the applicant's defense are too extensive to address in full now, so I will focus on 2 points. First, the failure to delineate the appropriate region of influence, and second, the omission of any construction noise analysis. If I have time, I'll address some of the technical deficiencies in Hunt analysis. Before explaining why the applicant's response fails to eliminate the substantive and significant issues raised by Sandstone, I want to note that the deficiencies in the Hunt study also affect the community character analysis. The region of influence for noise helps, in the context of Dr. Fladd's cultural landscape analysis, to explain why the region of influence for community character extends at least through the counties surrounding Seneca Lake. The failure adequately to mitigate noise impacts has an adverse impact on community character, even for those community members who are not within earshot of the noise. The applicant begins its critique of the noise study prepared by Sandstone with a series of slurs, claiming that the report ignored reality and made inappropriate leaps of faith about what can be heard across the lake. In fact, Sandstone was the only noise analyst that paid attention to reality. Consistent with DEC noise guidance, Sandstone assessed noise impacts in context, considering the use of land surrounding the facility, including recreational uses such as fishing and boating, and the character of the lakeside community, whose residents are actively seeking to preserve the peace and quiet that draw tourists to the region. Sandstone also was the only noise analyst that actually measured noise levels on both sides of the lake. Instead of assuming that nothing could be heard on the eastern side, or that they didn't have to look, Sandstone investigated residents' concerns and documented the fact that noise from the west side carries to the other side of the lake at potentially intrusive levels. Turning to the region of influence, Sandstone's on-the-ground research demonstrated that the applicant had delineated an inappropriately confined region of influence. It's important to delineate the region of influence correctly, because if it's too narrowly defined, potentially significant impacts may not be identified. Sandstone demonstrates that the applicant made 2 fundamental errors in defining the region of influence. First, only on-site noise sources were analyzed, even though the project would cause significant off-site noise, especially from rail and truck traffic along the full length of Route 14 from Watkins Glen to Geneva. And second, only receptors on the western side of the shore were examined, even though homeowners on the eastern shoreline could hear noise across the lake. With respect to the off-site noise sources, the applicant says that there's already truck and rail traffic on Route 14, so project-generated noise would not be, quote, out of character. Impacts are based on relative increases in noise, not on whether similar sources of noise are already part of the noise landscape. Sandstone's fieldwork showed that the existing noise environment on the east side of Seneca Lake is a quiet natural setting with birds, squirrels, and rustling leaves providing the predominant background sounds. Although noise from trucks and trains does intrude, the result of adding more trucks and more trains, possibly at different times, late at night, for example, or on a weekend, when traffic is generally lighter, must be compared to background conditions. In view of the fact that truck and trail roading facilities will be capable of operating 24/7, 365 days a year, and there's no permit condition restricting either construction or operation to normal business hours, a noise analyst must assume that truck and train noise could be generated by the project at any time over the full length of Route 14 along the lake. Stating that trucks and trains already operate in the area is not a valid reason for excluding analysis of impacts. If that were an acceptable approach, no traffic noise analysis would ever be conducted. With respect to the receptors on the east side of the lake, the applicant asserts that locating receptors anywhere other than on the property line or on adjacent property is contrary to DEC noise policy. DEC's noise guidance is designed to help its staff implement secret, not to defeat the statute's purpose. Generally, looking at the property line or adjacent areas is a conservative approach. But when a loud noise can be heard farther away, it is neither conservative nor consistent with SECRA to treat a guidance document as a rigid rule that allows the analyst to ignore the impact. This refusal to consider the facts is a familiar refrain. We point out evidence of a problem, they cite guidance or the scoping as a reason to avoid study, and it really makes you wonder whether they're afraid of what they're going to find out. The applicant mocks the idea that noise should be monitored across the lake, but EISs in New York have examined noise impacts beyond the immediate adjacent properties, and some receptors were thousands of feet from the source. Over land, in the Bel Air DEIS, they had a 1 mile radius from the source for noise receptors. And in Sterling Forest, again over land, where transmittal of sound is attenuated more than over water, they had a 4,000-foot radius. The applicant has failed to deal at all with the fact that noise is attenuated less over water, and that it alone is a reason for an adjudicatory hearing. Construction noise. The applicant provides no analysis of noise impacts during the construction period, even though heavy equipment will be used and the number of workers traveling to the site during construction would be about 5 times the number of permanent employees. In response to the critique of the failure even to identify construction schedule or what kind of equipment would be used, Hunt referred us to the Stormwater Pollution Prevention Plan. The public should not be sent hunting to the SWIP to find basic information that you need for a noise analysis. Moreover, simply because construction noise is temporary does not mean that it should not be evaluated. Sustained noise levels that are 70 to 80 dBA in sound level, or are substantially louder than ambient noise levels, may occur throughout the day during construction. If they occur over a period of weeks or months, they will be very disruptive to residents and tourists, regardless of the fact that they will stop when the facility is complete. DEC's noise policy recognizes that construction noise should be evaluated in both its first level noise impact evaluation and in its provisions for mitigation. The applicant also asserts that the construction activities on site are typical of the construction season. This again confuses the the idea of the quality of the source and the level of the noise. There is, moreover, no evidence in the record to support the assumption that heavy industrial developments of similar size and duration are typical of this area. Even if the proposed activities could be considered typical, however, they still would require analysis of the impacts. In sum, we have established a substantive and significant issue about noise in this case because there is sufficient doubt about the applicant's ability to meet statutory or regulatory criteria applicable to the project, such that a reasonable person would require further inquiry. Because the project cannot meet the requirements of SECRA, the DSEIS fails to take a hard look at the potentially significant noise impacts, including construction impacts, within an appropriate region of influence, and the project is not the alternative that avoids or mitigates noise impacts to the maximum extent practicable. Therefore, DEC will not be able to make all of the findings required. It's also significant because the failure to mitigate the impacts is grounds for denial of the permit, particularly in view of the contribution to the adverse impacts on community character. And if the permit is not denied, the noise impacts should result in the imposition of significant additional permit conditions. Sandstone has identified 16 different areas of analysis that still require attention. It's impossible even to identify what mitigation is necessary at this point until those analyses are complete. Thank you.
Does your sandstone report do the analysis that it suggested should be done? Did it go to the east side of the lake and take some measurements of receptors that it thought were appropriate?
Yes, Your Honor.
Okay.
Yes.
Morning, Your Honor. Gas-Free Seneca has not raised a substantive and significant issue regarding noise. Each of the so-called deficiencies identified in their petition are fallacies. The approach that they suggest to conducting a noise analysis is not consistent with any noise analysis reviewed in any administrative decision by the department in discussing noise. Two recent examples I'd give you is Seneca Meadows rulings on March 26, 2012, and then Dalrymple in 2003, decision of the commissioner. And I'll get to those a little bit further. And there's also an older precedent as well, WA aggregate decision of the commissioner. What Gas-Free Seneca is attempting to do is, in essence, rewrite the noise policy. And the noise policy, the fundamental purpose of the noise policy is to assist the department in evaluating whether or not the applicant can comply with certain statutory provisions, including SECRA. There's a whole list of statutory provisions in terms of the background contained in the noise policy. And it explains the purpose of that. And that's exactly what was done with Hunt Engineers. It's exactly the approach they took. The methodology that they employed was proper. It was consistent with the noise guidance. It even talks about first order, second order analysis, consistent with the noise guidance. It's consistent with directions from the department, including ultimately what was included in the final scope. And most importantly, it properly evaluated noise impacts and demonstrated that noise impacts can be mitigated and minimized to the maximum extent practicable.
But the policy is not a reg.
It's not a reg.
It's just a document that helps assist in guiding the department's exercise of discretion in doing its review, correct?
And that's correct.
So isn't it possible that maybe there might be some other things that should be considered that aren't necessarily reflected, squarely in the policy? Does the department have some leeway to examine a few other additional receptors beyond the typical ones that would be done depending on the circumstances of a case?
I would suggest that iterative process did occur at the outset of the application here, and in the context of the SECRA review that was conducted.
Was some consideration given to the fact that you have a flat lake next to this site that might, as Gas-Free Seneca suggested, does not attenuate sound the way sound traveling over open territory might?
Consideration was given to the location of the closest receptors, not necessarily at the property line, and what the noise generating sources would be and where they're located. For example, one of the noise generating sources is a well pump right on the edge of the lake. And so that was evaluated in terms of what the noise would be from that noise source. And as a result of the analysis that Hunt did, it was determined that appropriate mitigation. Now, Gas Free Seneca says that we didn't consider mitigation or incorporate mitigation into the analysis, but that's not accurate. There are two noise sources where we actually did incorporate into the design as a second order analysis under the noise guidance, mitigation including structures and then also berms around some of the pumps.
Was there a receptor located east of the pump? Near
The lake.
The
It's
lake
right on the
itself?
lake, yes.
There was a receptor?
Well,
there?
the noise source, it wasn't a
Was it measured?
receptor.
That's what I'm asking. Was there a measurement done at the lake?
The noise source itself was measured, and then we decided it was appropriate to put the well pump within a cinder block enclosure, which would reduce that noise source by up to 40 decibels. And so, because of the noise source itself, even though the well pump is only for emergency purposes and will only be tested twice a year, even though it's not a continuous noise, we decided that we would put an enclosure around the well pump, and that's the only noise source that is close to the edge of the lake. It's really on the edge of the lake. And all the other noise sources and receptors were evaluated according to the typical way that the guidance suggests and the typical way that administrative decisions evaluate. For example, in the Seneca Meadows case, in terms of background noise levels were measured in the adjoining community at 9 locations along the boundaries of the project site. Modeling was employed to assess the noise environment around the project site over the life of the mine. The Dalrymple decision talks about how the noise impact guidance is very clear in this regard, stating that appropriate receptor locations may be either at the property line on which the facility is located or at the location of use or inhabitants on adjacent property. This means that either the property line of the proposed project can be used, or if appropriate to the circumstances, receptors can be located upon adjacent properties at points remote from the property line if the actual use on the adjacent property is at some distance from the property line. And that's exactly what was done here.
But neither Seneca Meadows nor Dalrymple were sited next to a very large flat lake, were they?
They were sited next to residences.
Right, and you measured residences, but the objection I'm hearing from Gas Free Seneca is that there's this lake that needs to be taken into consideration that doesn't act as an attenuator, and that some consideration needs to be made in the noise analysis.
And what I think Hunt said in its response, that even if you reduce the attenuation level because of distance only, not taking into account any other factor, that still there would be a delta between what the ambient is and what the resulting noise level is by less than 6. In addition, there's already an existing noise level in the area. Route 414, for example, which is on the other side of the lake, is a state highway, and there are trucks traveling that highway.
Are there trains over there too?
There are no trains over there, but there are existing trains on the west side of the lake, and that's part of the background noise that exists now. And this project will not measurably add to that train traffic.
But we don't actually know what that sound level is over there because it hasn't been measured.
Well, what we do know is what the level is on our side of the lake, and therefore, just simply by virtue of distance attenuation, what it would be over on the other side.
And Hunt took into account a flat lake when it drew that conclusion.
They did not evaluate in their report the lake itself. They just evaluated nearby receptors, and that was really appropriate under the guidance and under existing administrative case law. There was no need to evaluate receptors 4,000 feet away when, in fact, receptors only 1,000 feet away were saw less than a 6 decibel increase.
And those were on the west side of the lake?
Yes.
Those receptors.
Yes.
But that didn't have an intervening lake in between them and the sound source.
Well, that's correct, but those sound receptors were probably 4 times the distance from the closest receptor that we did model. So Hunt considered, and in response to Sandstone, they considered that, and they said it wasn't necessary to do, and it would not have shown any increase in impact different in character than the kind of impact that you have based on their noise evaluation.
Well, Casper Seneca did their own study. Did Hunt look at what their results showed? And my understanding is that I don't recall completely, but Ms. Goldberg indicated that they did their own measurements.
Well, they did their own measurements, first of all,
Is there
during a
something
time of year when it wasn't appropriate to do, because the guidance suggests that ambient measurements should be taken actually in the summer months, not in the winter months. So
But you
that's
took it
one
in the
problem.
winter months as well.
We took it both times.
Okay.
Yeah, we took it both times.
So there's
So
nothing
we,
wrong
so,
with taking the winter months, is there?
well, no, but it's when the noise, it's not what the guidance suggests, and it's also when noise levels might be reduced because of less activity. So we took noise measurements, ambient noise measurements in the summer when the level of activity would most closely reflect what the background noise levels would be, as opposed to now when it's winter and all you really hear perhaps is snow falling.
Yes, but we can compare the two, can't we? I mean, you took, your study examined winter months, and their study examined winter months.
And we looked at summer as well.
All right, so was there something wrong with what the way they did their study beyond the time of year?
Oh, yes. I mean, I think that it substantially prejudices the value of the level of ambient noise levels that they're taking by only taking it during one particular period of time, when it does not necessarily reflect reality of exactly what those who are on the east side of the lake will be experiencing. So that's a serious deficiency with what they did. In addition, I think another serious deficiency is ultimately their preliminary view, which I think is inconsistent, as I said earlier, as to what is the geographic limit of what you should really be looking at. Those cases that were mentioned were different in kind from this one. This situation went through a back and forth with the department as to exactly what would be scoped and what would be evaluated, and it was determined that what we would look at were the nearby receptors, and there's no receptor, there's no house in the middle of the lake. Okay, so
Well, nobody's contending that that's...
right. So and that's exactly why we looked at the nearest receptors, took a look at least initially distance evaluation, and we ultimately determined that there's no impact. Where we saw some potential impact with regard to the injection pumps, with regard to the well pump, we actually added buildings around those structures to further mitigate noise. And we were conservative in that regard because we actually didn't take the ultimate reduction that we could have. We took maybe an 8 decibel reduction for structures around the injection pumps and the well pump, and we could have taken probably up to 30 decibel reduction. But to be conservative, that's what we did.
What about the rail yard?
Okay, I mean, the rail activity that occurs now will not be much different than the rail that will occur once we're in operation. So we took maximum rail noise measurements in terms of potential noise sources and compared those to what the ambient level is now. And we tried to differentiate the two just to see whether or not, what the increase in full train activity would be versus what the ambient is. And we found that there was maybe one location where we were at the 6 decibel increase, and that is the location of the, actually the LPG trucking company right next to the surface facility site, and who was a supporter of the project, JM Trucking. So there was one location at where, I mean, the noise guidance suggests, based on noise expertise, Leo Baranek and a number of other sources, right in the noise guidance, that certain increases are tolerable and do not rise to the level of creating an adverse impact. And at the minimum, if you stay at 6 or less over the ambient, that's satisfactory to show that you've minimized environmental impacts and satisfy basically the seeker standard, which really where this falls under, the seeker standard.
So you're currently bringing in trains now and loading them?
No. There's train traffic along the same
Right,
rail
yeah,
line.
But aren't you going to be bringing in trains
Yes.
to a rail yard
So-
where they're going to be loaded
Yes.
with product? And that was analyzed, I presume?
Yes, what we did is we went actually to a similar facility, and we took noise measurements while those rail activities were occurring, loading and unloading. And we compared those to what the ambient was in the area where the facility is proposed to be located.
And so I just want to make sure I understand. So, and no mitigation was required because the additional noise was below or within the tolerable range as defined by the DEC policy, is that correct?
That's correct.
So you haven't done any mitigation around the rail yard?
No, there was none necessary.
All right.
And in addition to that, I think that the rail activities, when those activities will be occurring, will be of short duration as well.
But they could be happening at night, right?
Perhaps, but it's unlikely. I think it's more likely that they would occur during the day. And, you know, it's true.
But there's no limitation, Gas Recycling is correct, there's no limitation on your operations in the permit at this point in order to avoid, say, noise at night.
No, there isn't, but I think that we explain in the application documents when we expect the facility to be operating, typically from 6 a.m. to 6 p.m., and not all of that time will there be occurring either rail activities. It's typical that it would be that basically during the work day that these activities will be occurring. There's no guarantee that it won't at night, but typically now, even when the rail line operates, it operates during the workday, and that's what we've indicated in the application documents. So that may not be in the noise study, but it's certainly in other documents that we presented, including in the DSEIS. So, I mean, we conducted a proper evaluation. We looked at the noise receptors surrounding where the noise generating sources will be. We actually were conservative in terms of proper attenuation, and even at the edge of the lake, it was determined that there was no adverse impact as a result of noise. In addition to that, given the noise monitoring that is required as part of the permit, as additional mitigation, and additional mitigation would be required if for some reason the modeling doesn't hold true. For some reason, we have to act under the permit, and so that's additional mitigation that I think that the Gas-Free Seneca has not taken into account, again, since they say that there's no mitigation. So given all that, given the burden of persuasion that petitioners have, and given the established precedent in terms of how we went about things, in terms of the evaluation, we don't think that there's a substantive and significant issue.
Thank you. Part of that.
Your Honor, I do have an entire statement, but I think you were asking a question before, and I'd like to point something out to you. Gas-Free Seneca's sound evaluation and the levels of sound they projected at their receptor A range from 33 to 44 dBA. All right, at their receptor A, on the other side of the lake, not on the same side as the project, I believe that's the east side of the lake, range from 33 to 44 dBA. In our noise policy, areas 35 dBA is characterized as a wilderness area type of sound. 45 dBA is characterized as a quiet, seemingly serene setting, such as rural farmland.
I'm sorry, 45 dBA?
45. So the study that Gas-Free Seneca shows does not show a significant impact on the other side of the lake. And that isn't to concede that. I think that their study is perfectly in line with our policy or perfectly good. All right, now I'm going to go back to my real spiel. The department staff's position is that noise isn't an adjudicable issue because it's not substantive and significant. Just to make sure you understand where we started out with our process, the noise impacts from the proposal are discussed in section 4.3 and appendix 1 of the DSEIS. The original study of first level noise impact analysis dated January 5th, 2011 was modified in May 2011 to reflect comments offered by the department in its April 28th, 2011 letter. The sound study was again updated in January 20th, 2012, a transmittal to the department to generally reflect the reconfiguration of the site, in partial response to comments. The sound study was updated again in July 2013 to clarify and correct data from one of the sound sources, the brine pump. And finally, a supplement to the July 2013 study was provided dated March 7th, 2014 to evaluate potential impacts to receptor 7 using ambient noise measures taken for the Arlington Gas Storage Company, the Gallery 2 expansion project, which was pending before FERC at that time. So the July 2013 sound study and the March 7th, 2014 supplement are identified on our document list as Roman numeral 1B32. Go back. The department staff's position is that the applicant's sound study was conducted in a manner consistent with the DEC program policy DEP 001, the DEC noise policy. The position is that nearby receptors were properly identified, representative ambient noise levels were obtained, project noise sources were properly estimated, and expected changes in noise levels were properly estimated. To drill down and hit some highlights. Based on projected noise levels for the Finger Lakes project operations, including proposed mitigation measures, the expected noise level increase at each receptor, is 6 dBA or less. So under our policy, that would not be a significant impact. At receptor 7, a daytime increase. Just so you know, department staff got some information when the Arlington project was being done.
Receptor 7.
Where is it?
Yeah,
The hotel?
the hotel.
The hotel, in the back of the hotel? East side of Route 14A?
All right.
Route 14, sorry. Okay. So department staff, in the processing of the application, also looked at some information that was available and is available publicly in the FERC proceeding that had to do with Arlington Gas Storage that was pending at the time, a study done by Hoover and Keith. And in looking at that, there was some data that was taken at a receptor that was close to the Finger Lakes receptor. And in looking at that and evaluating, staff determined that at receptor 7, a daytime increase of 7.9 dBA could be projected under a worst case scenario. That is to say, worst case being where all Finger Lakes equipment would be operated at the same time as the equipment for the Arlington Storage Company. That represents the addition of, the 7.9 represents the addition of equipment noise from Arlington of 47.3 dBA. And equipment of Finger Lakes of 46.6 dBA. And then you add them in accordance with the adding requirements of the noise policy, which is not the same as 1 + 1 is 2. But you get to 50.3. So we want to point out, though, that even for this instance, the estimated sound level of 50.3 dBA is still well below 65 dBA, which is the maximum recommended sound pressure level in a non-industrial setting in the DEC noise policy. In addition, as noted in the DEC noise policy, EPA's protective noise level guidance found that ambient noise levels of 55 dBA LDN were sufficient to protect public health, and in most cases did not create annoyance. As a result, the 50.3 dBA did not give us enough concern to say that that wasn't in accordance with the noise policy. We would still say that the study and the results are in accordance with the noise policy, but I will point out also that we have a permit condition that requires confirmatory study and mitigation measures if what was predicted doesn't come true. So that's kind of it in a nutshell from the department staff's perspective. We do have a few things to say.
The 60 standard, that's for a rural setting?
60. I said that the
50.3, which
50.3
is a cumulative. That's both Arlington and Finger Lakes operating together.
worst case scenario, Arlington and Finger Lakes, everything going at the same time.
And that's below the 60 you said. Is that
Below the 65 dBA, which is the maximum recommended sound pressure level in a non-industrial setting in the DEC noise policy.
non-industrial? Is
So
that
it's-
different from a rural setting?
It just says non-industrial in the policy.
There is no rural setting, or there's no rural figure in the policy? Well, I can look.
I don't know off the top of my head, Your Honor, so if I just try and glance through this right now, I might give the wrong answer. I can put in the brief.
Right.
Okay. So let me say just a little bit about the sandstone noise review. Department staff's policy is that contrary to the claims made in the sandstone report, the evaluation of off-site truck traffic and train noise is beyond the scope of the action under review and need not be addressed. Rail lines and highways serving the site already exist and already carry train and truck traffic without the project. Apart from the rail siding and the turnaround area, and that's important, I mean, obviously we evaluated the railroad noise that was right on the site, and that was important to us. It was a primary consideration. But other than that, no changes to the existing rail or highway facilities are proposed as part of this project, and we don't believe it's appropriate for us to evaluate them. It's also our position that potential receptors were properly identified in the applicant's work, including which meant properties surrounding the proposed facility on the west side of the lake, the project side of the lake. And
would the department ever look at, just to, to evaluate a potential impact, if there was a significant increase in truck or rail traffic as a result of a project, would they look at the noise impacts of that?
I don't know, Your Honor. I don't think so, but I don't want to say that what I'm going to do tomorrow on a different project that's not the fact here. You know what I'm saying? I mean, right now I know that that the trains are going to come by anyway, and if I remember correctly, that we shouldn't have more than one extra train trip per day. In other words, it should be extra rail cars on the back of the trains that are already going through. And at most one extra train per day. That's what I believe. I don't remember where it is in the record, which is a problem that I have. But and as far as the truck increase is concerned, I told you about the DOT letter yesterday, and I told you about the department staff's own, evaluation to check up on DOT of we don't think over in 14 it will be more than 1.4 and 14.8 it'll be more than 1.2% increase. So. In this 1.2 decrease in the truck traffic on 14 and 14A, not more than 1 point, and in some cases, in some places, less than that. So I can't speculate to a project in the future where there's a 99% increase in traffic, maybe in a different kind of a neighborhood. I mean, I don't know, but right here and right now, on this situation. It doesn't seem reasonable to go beyond both our policy, our practice, and the situation doesn't call for it. All right.
Your time is up.
Is it?
Yeah.
Okay, we're going to brief this, Your Honor. Is that okay?
Right.
Great. Thank you.
Wonderful.
So let me start by addressing some of the issues that were raised by the department. I point out that nobody, neither the department nor the applicant, addressed the fact that part of the region of influence problem occurs on the west side of the lake. There are traffic impacts that go up and down the highway and the railroad on the west side of the lake. Those continue the whole distance. They're not just on the project site, and there's nothing in the report right now that addresses them. To suggest that you don't look at traffic impacts, it strikes me as absolutely absurd. If you have a shopping center that's generating a lot of traffic, you're going to ignore all the noise through the neighborhoods because you're not changing the street configuration? I don't believe that the department would actually allow a developer to create a new traffic and not analyze the noise impacts along the routes that are taken. Secondly, The condition in the permit, which does require additional monitoring if there's a problem, covers only the existing receptors. So if you start with the wrong receptors or an inadequate region of influence, you continue the problem that you started with. The department says that the...
So if we added the receptor across the lake that you propose,
if we
would
add,
that satisfy?
If you make a determination that it's necessary and there is a need for a new noise study and direct the applicant to do a new noise study and they add the appropriate receptors, that would be wonderful. I think that it is something that the public should be entitled to review and comment on. It will be brand new information. They've been ignored in the past. But if you would direct them to do an additional noise study and an additional community character analysis and additional cabinet integrity studies, if all of that is required and there's an additional public process, I would not have an objection to that. But if what we're going to do is just move to, consider or not whether or not there's a factual question here, there's plainly a factual question in dispute here, and there's a need for an adjudicatory hearing on it. The department suggests that the noise that we analyzed in the wintertime showed only a 33 to 43 dBA sound level. Now, we had no choice but to do this in a brief period of time between the announcement of the initiatives conference and the submission of our paper. So we're in there doing that. And our study was based on a measured noise of 81 dBA. But Hunt, in its response to us, said that the maximum noise level is 88.9. And Hunt's conclusion is, and I will read directly from it so as not to misstate it, neglecting any reductions over the water, the maximum on-site noise level of 88.9 dBA train activities would be perceived on the eastern shore as 51.9. Now, the baseline that our expert identified was in the mid-20s or high 20s. If you assume 30, you've got almost a 21 dBA increase, and that's a significant impact. That's based on their own statement, allegedly rebutting our analysis. Again, the fact that there will be only one whole train in addition strikes me as not a reason to avoid analysis. As we indicated, that adds to the frequency of the trains, and we still don't know when those trains are going to be coming through. Likewise with the traffic. It may be a small increase, but the timing makes a big difference. And of course, for the community character impacts, what those trucks are carrying and what those trains are carrying makes a difference as well. The applicant says that we understated the baseline because we did it in winter. Well, we obviously had no other choice. But the guidance does not tell the analyst to analyze in summer. What it says is people generally have their windows open during summer, and therefore there's less attenuation by the buildings in which they're enclosed.
But we can compare apples to apples, right? Because if we've got yours in the winter, we've got theirs in the winter, we can at least compare something.
Yes.
Relative.
Yes, Your Honor. That would be possible. He also misstates what the baseline would be like. It is the east side and the west side are not comparable because the receptors along the shore are buffered by forest that's growing up the side of the hill. The Route 414 that's on the western side of the thing is up above the homes that are down below on the eastern shore. So you're not hearing truck traffic from the highway, the way you are on the western shore, which is right along open fields. So we did not say that there was no mitigation. I'm perfectly aware that there's some mitigation and that there is a monitoring requirement. What we said was it's not nearly adequate given the failure to consider the full range of construction noise. And I will note that nobody mentioned the construction noise either. And that's for the receptors on the western shore as much as it is for the receptors on the eastern shore. So there's still whole areas that have not been covered at all, both the receptors and the sources. And that presents an adjudicable issue that requires a hearing.
Thank you very much. All right, so that's noise. Should we take a brief recess? Would you like a break? Or should we soldier on to alternatives? Break? No? Let's go ahead. All right, we're going ahead. So the Seneca Lake Pure Waters Association?
In Seneca Lake Pure Waters petition for party status, we asserted that the DSEIS fails to identify or analyze a reasonable range of alternatives for the proposed storage project. The department's regulations require that alternatives to the project must be provided and that the no-action alternative must be considered. The only alternatives discussed in the DSEIS are alternative locations for the brine ponds. There is no consideration of any site, any alternative site for the underground storage facility, nor is there any consideration of the no-action alternative, not building the facility anywhere. The failure to discuss alternative sites or the no-action alternative is a fatal defect in the draft SEIS and can only be cured by issuing a new draft. Alternatives that could have been considered but were not include building the facility away from Seneca Lake and nearer a rail line that does not have the safety issues that are posed by the Watkins Glen line. Another alternative that was not considered was the alternative of building the caverns in a non-salt bed and moving the storage caverns farther away from fault lines, particularly the Jacoby-Delwig fault that it is sited right next to. And in these, in considering alternatives, the applicant has talked about the TEPCO storage facility, which is still in the area, but it's very instructive, sort of the history of that facility is very instructive to a consideration of alternatives. From 1964 to 1984, TEPCO stored LPG in a cavern in the salt bed, right next to where the proposed site is. But in 1982, well, and I'll just say that it has already been pointed out yesterday that during that time, the salt levels in the lake went up very considerably. In 1982, TEPCO obtained a DEC permit to dig a new cavern in the Genesee Shale. So, for whatever reasons, TEPCO decided to move out of the salt beds and dig a new cavern in the Genesee Shale, which is much closer to ground level and far removed from the salt bed. And they lined, that new cavern is entirely lined. I have heard by steel, I'm not certain exactly what the lining material is, and TEPCO transferred its LPG storage materials to that new site. According to articles in the press by Peter Mantius, the DEC has denied his FOIL requests for any records which might explain why TEPCO spent the money and the time to move its LPG storage facilities out of the salt bed. But surely that is an inquiry that needs to be conducted in connection with this proposal. Why did TEPCO move? Why did TEPCO move out of the salt bed? So when we're looking at alternatives, that should be part of the discussion of alternatives along with other discussions. So as I have said, the failure to include any discussion of any of these alternatives cannot be cured by a discussion of alternatives in a final EIS. The DEC must be required to issue a new draft EIS that analyzes clearly reasonable alternatives. And I'd like to reserve the rest of my time for rebuttal.
All right.
Thank you.
Gas-free Seneca.
Thank you, Your Honor. I'd like to reserve 2 minutes at the end of my time for rebuttal, please. Under Section 624.4 of DEC's regulations governing issues conference, Your Honor is empowered to determine whether legal issues exist, the resolution of which is not dependent on the facts that are in substantial dispute. It is our contention that the draft DIS contains 2 fatal flaws that cannot be corrected in a final SEIS and require by law that DEC complete another draft and resubmit the new draft for public comment and review. The 2 flaws that we will discuss right now are the failure to include the no action alternative discussion and a failure to discuss sufficient reasonable alternatives to the project. With respect to the no action alternative, there is no doubt, and the applicant does not dispute, that SECRA requires an analysis of the no action alternative in an EIS. The purpose of this is to create a baseline to which the public and the department can compare the impacts of the proposed project as well as its reasonable alternatives. Under SECRA, in Section 617.9B55, the no action alternative discussion, and I'm quoting here, sorry, the no action alternative discussion should evaluate the adverse or beneficial site changes that are likely to occur in the reasonably foreseeable future in the absence of the proposed action. In other words, the EIS must consider the capability of the site to environmentally improve, recover, or allow for restoration and remediation in the absence of the proposed project. These requirements clearly go far beyond what has been included in the current draft, which by the applicant's own admission discusses only the current environmental setting and the financial benefits of pursuing the project. Contrary to the applicant's assertions, the petitioners are not elevating form over substance here and looking only for a section in the draft titled No Action Alternative. The petitioners are looking for an actual discussion of the beneficial impacts of opting not to proceed with the project. The cases cited to by the applicant in support of its position that what's in the draft currently is sufficient actually are predate revisions to the SECRA regulations, which explicitly include the requirement to examine the future conditions without the project, a requirement that the draft does not fulfill. The applicant also cites to a reference in the SECRA handbook, which provides that for many, but notably not all, private actions, the no action alternative may simply be the direct financial effect of not undertaking the action. Given the many issues being raised by the petitioning parties in this case and the lengthy discussions Your Honor oversaw yesterday and today, this clearly is an example of a project where a description of the financial benefits of the project and of the current environmental setting is not a sufficient characterization of the no action baseline that SECRA requires. This is a fatal flaw under SECRA and by law requires the reissuance of the draft. The other flaw that we would note is the absence of the discussion of the reasonable alternatives. SECRA requires an analysis of all feasible and reasonable alternatives to the project. And as has already been noted, the only discussion in the draft are of 3 potential brine pond changes. There is nothing that discusses alternative siting, alternative project sizes, using different caverns, other design changes, including how much LPG is brought into the facility via what mode of transportation. The applicant cannot contend that there are no reasonable alternatives that it failed to consider because only 2.5 months ago it released a revised transportation product allocation where, for the first time, it contemplated apparently eliminating the use of trucks and using only rail and pipeline to bring the LPG to and from the facility. This alternative was never mentioned, let alone analyzed in the draft. We would note also that the applicant would like to take credit for eliminating truck transportation, but by, for example, not analyzing the risks that such truck traffic would cause and concluding that the risk is 0 in the Quest QRA discussed yesterday. But as the department noted, and as your questioning elicited, the applicant still intends to build the truck depot and there is no draft condition that would restrict the use of trucks. Bottom line is that the applicant seems to want to have it both ways, claiming credit for eliminating impacts when it suits them, and then keeping options open without evaluating the full slate of impacts and alternatives. The importance of including reasonable alternatives in the draft for public review and comment is underscored by this example. Eliminating truck traffic, assuming that's what they're doing, has the potential to alter the adverse effects posed by the project.
Although there would not be increased truck traffic from operating the facility if the applicant did in fact not use trucks, the applicant would have to rely on a greater use of the rails, and as we discussed yesterday, there are risks associated with that. Because this alternative and its associated impacts were not discussed in the draft, neither the public and not even potentially the department has a good idea of what this change means in terms of adverse impacts of the project. Had this alternative been included in the draft, and the impacts of this alternative discussed and compared to the impacts of the project that was proposed in August 2011, we would have understood those implications. Also, underscoring the importance of having this impact include this alternative and other reasonable alternatives like it in the draft is underscored by the fact that by eliminating the truck traffic, they have potentially fundamentally altered the potential benefits of the project and which affects the claimed purpose and need of the project. If the LPG no longer is transported via truck, it is much less likely that this LPG stored at the facility will be going to local customers. If they put it on pipeline and rail, it is more likely to go farther distances and serve farther flung markets. So therefore, the local customers are not going to benefit from the apparent price spike decreases that the applicant claims will result from installing this project. Instead, other customers in other parts of New York or New England will benefit. The result is that the local communities will be forced to take all of the risk on associated with this project and receive almost none of the benefits. Again, this is not discussed in the draft at all. As a result, as currently written, the draft is insufficient under SECRA, and it would be insufficient to correct these errors in a final, which would not be subject to public comment or review. As the Court of Appeals held in Webster, the purpose of requiring inclusion of reasonable alternatives to a project, and I think this is equally applicable to the no-action alternative, is to aid the public and governmental bodies in assessing the relative costs and benefits of the proposal. Such major defects cannot be cured merely by including the missing information in the final. A new draft must be issued. While the applicant, and that new draft must be subject to public comment and review. While the applicant attempts to style this as a request for a supplemental EIS under 617.9, it is not. The draft is fundamentally invalid and must be redone. This is precisely what the DEC did for the S-guys on fracking. The original draft was deemed insufficient, and it was issued, and the department issued a revision. That is what we'd ask Your Honor to do today. Thank you.
The Seneca Lakes communities.
Your Honor, I would reserve 2 minutes for rebuttal. The applicant's failure to consider a range of reasonable alternatives is a fatal defect in the DSEIS. SECRA requires that all draft EISs must include a description and evaluation of the range of reasonable alternatives to the action that are feasible, considering the objectives and capabilities of the project sponsor. The amount of detail that must be in each EIS about the alternatives needs to be enough to permit, quote, a comparative assessment of the alternatives discussed. And the purpose of requiring this is to help both the public and governmental bodies assess the relative costs and benefits of the proposal. So to be meaningful, that assessment must be based on an awareness of all reasonable options other than the proposed action. Reviewing a range of alternatives is crucial to SECRA's fundamental mandate, weighing the need for this project as planned versus the feasibility of meeting that need in a less intrusive manner. The alternatives analysis has in fact been described as the heart of the SECRA process. What the applicant offers here is totally insufficient to meet the regulatory requirements and the fundamental purposes of SECRA. The entirety of the DSEIS's discussion of alternatives is focused on the brine ponds. There are 3 sentences on location, and all they do is confirm that the applicant decided not to consider another location. The applicant attempts to justify this by pointing to the final scope, but Your Honor, their reliance on the final scope is misplaced. The final scope does not shield the applicant, or for that matter the department, from being challenged in the permit hearing process for failing to obey SECRA. They're still required to comply with the law, and failure to do that is a potentially fatal defect in the SDEIS, final scope or no final scope. This is not an argument that seems to have come up very much in case law, but in St. Lawrence Cement Company, That case clearly rejects it. There, the applicant objected to petitioners raising issues of particulate matter impacts as well as other impacts like noise because, and I quote, they failed to raise them in the scoping process. The ALJ there held, and I quote again, "We disagree with this conclusion based upon our reading of the precedent and our review of the applicable regulations. The department's intent regarding changes to section 617.8 was to limit the scoping process by requiring information raised after the preparation of a final written scope and prior to the completion of the DEIS to meet a strict test for inclusion. This period does not include the Part 624 issues conference and hearing," end quote. Indeed, the ALJ in that case went on to say that, quote, "Given seeker's mandate to consider all potentially significant environmental impacts, to hold otherwise would not comport with statutory requirements. Given this precedent, applicants' repeated citing to section 617.8 G and H is misplaced. Those limitations on raising additional issues plainly do not apply to this issues conference." An applicant also relies on one line in the seeker handbook comparing a final scope to a quote-unquote contract between the lead agency and the sponsor. The handbook does say that there's a presumption towards seeing a final scope that way. But no agreement between DEC and a project sponsor can contract away seeker. Seeker has its origins in New York state law, and neither DEC nor the applicant has the authority to permit the other to submit a legally deficient EIS. In fact, immediately after the line they quote about contracts in the handbook goes on to say, and I quote, "The lead agency must still in all cases determine whether a draft EIS is adequate before opening public comment on that draft. If a lead agency believes that a late issue is important enough that the draft EIS must address it to be deemed adequate, then the agency should advise the project sponsor of that conclusion." Your Honor, the applicant is not somehow shielded from the fact that their alternatives assessment is totally insufficient. And given the project's needs and purpose as outlined in the DSEIS, combined with a significant number of concerns raised about this site both in public comments over many years and in today's issues conference, failing to discuss any potentially alternative sites is unjustifiable. The range of alternatives is supposed to be informed by the objectives and capabilities of the project sponsor, which in this case encompasses the entire Northeast region. The applicant's entire discussion of the project's needs and purpose is based not on the Finger Lakes region or even upon New York State, but on the Northeast region as a whole. The applicant begins that discussion by describing the size of the Northeast propane market. It continues by describing the arteries for supply in that market. They describe the need in terms of the imbalances in supply region-wide, and they promise that this project will make supply available, quote, "with large-scale truck, rail, and pipeline access." Descriptions of benefits to New York take up less than 1 page in the DSEIS and are very general. At no point does the applicant state in discussing project needs or benefits that the objective of this project is to provide supply primarily either to the Finger Lakes region or to New York State. Their focus is on the Northeast market, which is a huge area that should have provided a variety of potential alternative sites in a variety of different environmental settings. There is no reason, either in law or in this project's objectives and capabilities, to ignore alternative sites entirely. By doing so, the applicant has denied us the necessary awareness of reasonable options here, and they've made it impossible to weigh the need for this project as opposed to the feasibility of meeting that need in a less intrusive manner. For this reason, this is a fatal defect in the DSEIS. Thank you.
So we can't use the hearing process in order to supplement the seeker record on alternatives if it's determined that it needs to be supplemented?
We don't think so, Your Honor.
Why not?
In fact, we would...
Wasn't that what we were doing in St. Lawrence?
It was, but we would agree with what Gas-Free Seneca says, that the essence of considering the alternatives is not just a matter of supplementing the final record, but allowing future comment from both the public and from governmental bodies, which requires reopening the seeker process and allowing another public comment.
Well, in the Webster case, wasn't the problem solved by the fact that there had been discussion? That wasn't discussion in the context of the adjudicatory hearing. That was discussion, if I understood the case correctly, in the public generally. So we have an adjudicatory hearing process here that where parties such as yourselves have the opportunity to provide further comment on alternatives that are being proposed and whatnot. That would be sufficient. The only recourse the department has here would be to deny the permit or basically, and require further draft supplemental EIS. Is that correct?
Yes, Your Honor. Given the situation...
Do you have an example of that? Have we actually ever done that?
I don't have a site for you or can provide it in post-hearing briefing, But given the situation we have here, I don't think that we have had the necessary discussion outside of this process, nor do I think the necessary discussion will occur in this process to allow us to simply supplement the record. In other cases where supplementing the record has been acceptable, it has been based on discussions of alternative sites and information on alternative sites that's already available. The problem, Your Honor, and the reason that their DSEIS is insufficient is they have not provided the information that we and the public need to determine what alternative sites are available and to determine whether or not those alternative sites are feasible.
But if we adjudicate it, aren't we doing that?
Your Honor, I think...
Adjudicate the issue, then either the applicant would defend its current EIS or it would supplement it, and parties such as yourself have the opportunity to provide a record on the alternatives that you believe should be considered.
We do.
And our process is not robust enough to be able to do that for purposes of secret. Secret ordinarily only require public comment. It would require an adjudicatory hearing.
I agree, Your Honor, and this is an issue that could be and should be submitted to adjudication, but we do believe that it is legally deficient and requires reopening the secret process.
Okay, thanks.
Your Honor, if I may interrupt, I would ask that we have important information on this topic. We basically have a 4-page handout from one of our exhibits. If I could just distribute it in about 5 minutes to the screen. I believe it involves alternatives.
I don't have any objection to you distributing your handout, but at this point, I don't believe this was something that you raised in your petition, so that's why I didn't give you any time on this.
Well, we did talk about imposing conditions on the permit, particularly as it relates to truck and train traffic. These are the projections that we have done at the county level on this.
And you presented your position on truck and train traffic, I believe, during the public safety portion of this conference.
Yes, in particular though, the issue of the truck traffic having been taken off of the permit application, I believe is a direct result of what we have done in our study.
Right, well, right now we're talking about the alternatives analysis under secret, so I have no objection to you providing your handout to the parties,
It's already published.
and then there will likely be briefing in this matter, so if you want to raise your concerns in your brief, that will be sufficient, I believe. All right, thank you. So, Finger Lakes LPG.
Morning, Your Honor. We have heard some extraordinarily remarkable, unprincipled positions on process, and I want to highlight them right away. So what we've heard, Your Honor, is we have a one-way street now that the opponents are proposing for this process that I've never heard of in 28 years. They're saying they could come in here, add to the record, keep the process open, add the record to show everything they want about the process, but nobody else can put anything into the record and nothing else can be looked at after that. In response to the last colloquy you had, I heard the answer that the development of this issues conference record is not enough. That you have to freeze the secret process, you have to freeze it before you start the issues conference, and anything that's not in or not to their liking, you got to start the whole process over. But they want to keep going in the same process, which is part of the secret process issues conference, and keep going through the process. It's incredibly unprincipled, it's unprecedented, and as Your Honor alluded to, there is no decision of this department or of a court that would allow such a process. So with regard to the subject matter that came forward, I want to address in terms of the alternatives, the no action alternative argument, the range of alternatives, and then I want to speak about scoping. The guest free Seneca spoke about the regulations, and once again, unfortunately, they didn't represent the regulations as to what they are. The regulations are very clear about the alternatives, and one of the things they didn't talk about at all is the case law, the administrative decisions about the difference between a no-action alternative between a public action and a private action. And that's what the Seeker Handbook talks about. And that's what we put in our briefs. And you didn't hear anything about that. The seeker handbook says, for many private actions, the no action alternative may be simply and adequately addressed by identifying the financial effects of not undertaking the action. That's what the handbook says. The handbook is still valid. It's not superseded. It is what the department's policy has been. And you go through the decisions, and this is going to be very important for all the alternatives discussion. With regard to private applicants, the standard is well established. So in terms of the no action alternative, let's turn to how that was met. And we put that in our brief. I'm not going to go into detail. We cite section after...
Let me ask you this. So do you recall what the no action alternative, how that was analyzed in the St. Lawrence matter?
No, I do not, Your Honor.
Okay.
Even though I was the attorney.
Did they simply rely on financial benefit in the St. Lawrence matter?
I do not know the answer to that question, Your Honor. And again, as Ms. Schwartz says, what one applicant chooses to do in one process is related to the circumstances that are extant there. It doesn't create, just because one applicant does more or additional doesn't translate into the argument you're hearing that it's a, quote, fatal flaw. And so there is no...
Well, in terms of what we might require of a private entity versus a public one, presumably there may be a range of, I mean, I'll have to go back and look at what happened in St. Lawrence myself, I don't recall, but presumably there's a range of what would be expected to be discussed. I mean, if it's a relatively minor project, the financial benefit would be sufficient, but in a more major project, perhaps not. Maybe some more expensive schedule would be required by the department.
Your Honor, that brings me to the next point, and I'm going to go right to it. Can somebody please tell me why we have scoping? The scoping regulations, if we're going to talk about scoping, and I think this is really important as to the policy and the decisions of Your Honor and any administrative law judge and the commissioner. Because basically what you have here is a situation where there was scoping, there were scoping hearings, and I agree, just because it wasn't raised in scoping isn't ipso facto a preclusion from it becoming an issue in 624. However, it is to be entitled to the weight that the regulations give it. And specifically, Your Honor...
So scoping didn't say, was it actually addressed in scoping that all that Finger Lakes had to consider was the financial benefit, that no action alternative needed to be discussed?
It didn't have to, because the seeker handbook states it very clearly. There was no issue raised. Scoping is to determine what issues are to be addressed, how they're to be addressed, and which issues are to be eliminated. The scoping process served that function because it didn't say, no, for this action you have to go beyond the, what the handbook says and do more. And frankly, nobody ever said that it had to, and it never even came up in these parties where it's scoping. So, Your Honor, my question goes to this, and it's a rhetorical question, because the seeker regs talk about scoping, and it says 617.8G, all relevant issues should be raised before the issuance of a final written scope. Any agency or person raising issues after that time must provide to the lead agency and project sponsor a written statement that identifies, goes through criteria, and then 3 is the important one. The reason why the information was not identified during scoping and why it should be included at this stage of the review. There's no record of that, and that should go to the weight.
Right, but isn't the no action alternative required in all cases, though? It's right? I mean,
it is
isn't that provision you're reading have to do with other project impacts?
No, this has to do with...
That would also apply to the alternatives that need to be considered as well?
Absolutely. Absolutely. Scoping applies to every single content of a DEIS, the mandatory ones as well as the voluntary ones. So this clearly applies. And my point is, Judge, just think of yourself as an administrative law judge, and somebody raises... Right. Well, in this circumstance, I was going to complete my sentence. In this circumstance, you had no issue raised before you with regard to a topic, and it goes to the appellate division, and the appellate division says, I think that there was an error. You never had an opportunity to address it.
Right, well, that's exhaustion of administrative remedies, but we're in the middle of an iterative process here. We haven't got to final agency determination yet, so this is this is an ebb and flow here, right? I mean, there's an attempt made early on in the process to scope the EIS, right? That was done, the draft is provided. Then we have a hearing process, which was referred here because staff believe there may be substantive issues that need to be adjudicated. And so then that's used to further supplement the record. So,
Judge, that's not my point. That's not my point. I've heard that discussion from you. My point, Your Honor, is this. My point is, how is this reg going to have meaning if they're not required to identify why it was not identified during scoping? That analysis would write the reg out. That analysis writes the reg out, that this has no meaning. So nobody has to ever explain why they didn't raise it below. My point is not that they can't discuss it.
Did they not raise this? Well, of course, they wouldn't have known what the no-action alternative looked like at the scoping point of this process because it hadn't been written yet, or right, the DIS hadn't been written at that point. So how would they know whether or not it had been adequately addressed in their view?
Judge, you just hit it before in your question. You said, was there a discussion in scoping about whether or not the no action would just follow the handbook or not? Why would, if someone believes you shouldn't follow the handbook, then somebody should raise that issue in scoping. My point is this, Your Honor, with regard to alternatives. This is particularly appropriate with regard to the range of alternatives. The no-action alternative, Judge, this isn't even an issue. I don't know why we're spending so much time on it. It's been addressed. It's been addressed according to the seeker handbook. There should be no further discussion about the no-action alternative. It to me is remarkable that we spent this much time on it because it follows the seeker handbook.
Okay. So then what about the other alternatives?
Yes.
That are being proposed?
Absolutely.
Were those raised during the scoping as things that need to be considered?
Absolutely not. Absolutely not. As a matter of fact, Your Honor, I stayed up till 1:30 this morning and read every single comment that was in the scoping document. And you want to know something else? Ms. Goldberg brought up community character this morning and talked about it. She talked about it several times. There is not one comment that says community character in the whole scoping document, okay? So the answer is, with regard to the range of reasonable alternatives, we want to talk about Webster. Here's what Webster has to say. Webster says that you have to look at the alternatives, and this is in the seeker handbook as well, summarizing Webster, must be viable, technical, and feasible. The regulations themselves talk about in the very provision that Seneca cited to you. It's remarkable that we cite to the same regulation. And it says, a description and evaluation of the range of reasonable alternatives to the action that are feasible, considering the objectives and capabilities of the project sponsor. Judge, the range of alternatives is determined based upon our objectives and capability. Our objective in this action is to store LPG in these caverns. These, not someplace in Massachusetts, for this area, for this market. We get to decide that. The law is incredibly clear.
Does Finger Lakes own other caverns in the area that could be used for this purpose?
No. Just checked and got the answer.
Right.
And so for a private party, and that's a very good question, for a private party, the law and the handbook are very clear. You don't have to go look beyond your own property, or, and I'm going to answer another question to make sure I get this right.
It's the only one located with the right takeaway option. My important is caverns where they are was the sole.
Is there any options in addition to owning? Because that's only we have options.
I'm trying to acquire from third party somewhere else.
But do you have it?
No.
See, because that's the test. Do you own or do you have options? And so we don't. So, Your Honor, this is also very important with regard to the law, and you hear all these statements about what the law is. They're misstating what the law is. When you look at the objectives and capabilities of the project sponsor. Now, in terms of the nature of the discussion of alternatives.
Let me just make sure I understand, though. Okay, so you don't own or have options on facilities that are specifically situated as this, with rail connection and presumably pipeline connections. Are there other sites owned by the applicant? Maybe have less advantageous rail and pipeline connections, but nonetheless are near such facilities? 30 plus miles away. So wouldn't that be a potential option, alternative to look at?
Your Honor.
It may be more, the costs and benefits of it.
Your Honor.
We're asking about other projects, so I'd like to confer with Mike.
All right. Well, maybe the thing to do would be that we can do some briefing. But
Your Honor, the range of reasonable alternatives, the department created the range in the scoping document. The question is, this isn't the time to start asking whether it could be done. The question here is what is reasonable, and Seeker has a rule of reason. No offer of proof has gone in to say for our Savona project that you should have looked in. They didn't mention that as an alternative. So we're talking about matters that they didn't even put in an offer of proof in, that we should be using other facilities we own. And Your Honor, with regard to...
So if the commissioner concludes that more alternatives should have been considered, we shouldn't use this process to do that? You would agree with the petitioners that say we'd have to start from scratch? I can't imagine we'd do that.
No, Your Honor, I wouldn't. And here's the thing, and I said this several times.
We use the hearing process in order to consider some other alternatives, like Savona, if that's what.
Your Honor, I'm going to say what I said yesterday. You have the adjudicatory issues conference in one bucket, and you've got the ongoing seeker process in another. I am emphatic that and I'm emphatic because the commissioner decisions are emphatic. You do not need issues conferences and adjudicatory hearings to solve and satisfy seeker. The decisions are legion in that. You can't.
Not necessarily, right. We don't necessarily have to adjudicate.
That's right.
We can supplement the secret record through the process. So
exactly.
Could we potentially do that here?
Yes.
Of the view that some further alternatives need to be considered, could we use the process to do that?
Absolutely, Your Honor, and I support that. I said I supported it yesterday for a number of issues. Listen, we're an existing member of this community. We've been so for a number of years. We're the largest employer in the town of Reading. The reason why the town of Reading in their comprehensive plan lists us as an important part of their community is because of the way we operate, because of our employees who are members of the community. We're not here to shut the public out. We have been responsive, and I've made this offer several times, and I'll make it again. I don't care if the issue was scoped. I don't care what the issue is, their concern is, as long as it's somewhat reasonable. We will address it in the response to comments. We welcome it. We continue to welcome it through that process. So I would support the commissioner doing that.
Something more we could do, though, beyond just respond to comments. If the commissioner concludes that some further alternatives should be considered, could a further draft be provided that would go into those alternatives and analyze them, and then allow for the process, the issues conference process to go forward and allow the parties to review it, comment on it, et cetera?
Judge, in theory, not for this case, but in theory, the judge has that power.
All right.
He is among many other powers. However, it's not appropriate here, and it's not appropriate on this record, to go cause a DEIS for a project that started in 2008. It's 2015. We had the DEIS complete in 2011. It is 2015 that we're even having an issue conference on it. So to me, it would be unreasonable.
Well, this was only referred to me a few short months ago, so I'm not sure I can take responsibility for what happened before. But
you can't, and we're not saying that you are.
So why is it okay? But so why is it inappropriate, though? I mean, we're trying to make sure that we have an adequate, full record for the commissioner to consider, assuming the commissioner ends up having to make a final decision here, upon which to make that decision, be able to make findings. So,
Judge, you asked two questions. The first one was, could the commissioner have that? Does he have the power? The answer, I said theoretically yes. Now I'm going to answer the other question as to why it's inappropriate here. Because the range of reasonable alternatives, and it's a rule of reason where the department staff gets deference because it's their expertise. The reason why it's not reasonable is because of the objectives and capabilities of the project sponsor. That's why it's not reasonable to reopen a DEIS process, to go through, start this all over again, to have another issues conference possibly based upon a DEIS for alternatives that are not reasonable. that is why I suggest the other way we can respond to these.
Commissioner decides it's reasonable to consider this alternative, then
If the commissioner considers it reasonable, he will have to change his decisions with regard to objectives and capabilities of the project sponsor. He will have to change administrative law, because the alternatives that have been put in the offer of proof basically get out of New York State. I've never heard a commissioner
all right. But
say that.
What about a local site though that's owned by the applicant?
They have to make an offer of proof for the commissioner to be able to order that as part of an issues conference, and that hasn't occurred.
Okay.
We have to have some process and respectfully for your process, the commissioner's process. We just can't come in the middle of a discussion on an issues conference and say we'd like to have this alternative raised when it's not in the offer of proof, it is not the way the process, well, you wouldn't have many applicants who basically will go through a scoping, agree, parties come out, nobody says why it should have been included, the reg's not even followed, and under your hypothetical, and I treat it as a hypothetical.
The petitioner may not have been aware of the sites owned by, other potential sites owned by the company. And the only entity that would be in a place to require that, certainly earlier on in the secret process, would be the department. Was the department, well, I can ask this to the department, but were they aware of other potential sites in the area owned by the applicant? And
Everybody was aware of they put it in their comments.
They didn't feel that there was any need the department didn't feel that there was any need to analyze those possible alternatives for the weighing of benefits and costs.
Not only the department didn't, but the comments and the offers of proof in here mention other facilities for other contexts. So I find it devoid from the record that they are unaware. They had the opportunity, Your Honor, you didn't even hear in the presentations today about the other facilities that the applicant owns. So, you know, I think that would create a precedent. Judge, you asked several questions. If I could just have a moment just to close up on a couple points.
Less than a minute, yeah.
Thank you. With regard to the alternatives analysis, with regard to the range of reasonable alternatives in section 5.0, I would like to note that you did not hear any comment at all in any submission that it didn't follow what was set forth in scoping. We followed what was in there. The range of alternatives is based upon our objectives and capabilities. Our objectives and capabilities are to use these caverns. The other point I wanted to make, Your Honor, is the alternatives and the range and those issues. Please remember what I said yesterday, which is this is an EIS that builds upon two other EISs, the 1988 and the 1992. These very caverns, the very issue of underground storage is addressed in those documents. Cavern integrity, everything is addressed in those documents. So, and we cite to them in our EIS, so it's not just this EIS. The no action alternative is also in, and it's even got the label, not that you need labels, is in those documents. So we believe, Your Honor, that that's very important also to the analysis, and thank you for the questions and comments.
Thank you.
Lawrence Weintraub for department staff. Your Honor, I was going to point out, as I think you already, I gather you already understand that, in the case that established that fatality rule, Webster Associates, the Court of Appeals held that the failure to include an alternative in the DEIS was not fatal, and because it was subject to much public discussion. I would point out here that in 2012, the applicant submitted to the department staff a document that's listed, that's in the hearing record, and that was provided to gas-free Seneca, and I'm sure it was foiled, that sets out the no-action alternative. And that is a letter dated February 16th, 2012. I don't have the number of the document.
February
But
16,
2012, but it begins on page 8, and I think it spills over into page 9.
And that was a letter from?
From the applicant to the department staff. Just stepping away into higher principles here is that, so what's the point of this process? The point of the secret process is for the agency to inform itself of the environmental impacts of its decisions. The point of the public process is for the public to help inform the agency of the environmental impact of its decisions. Well, this letter from 2012 informed us about the no-action alternative, which the department staff no doubt understood from the very beginning of this project, but it informed us, and the public has had it, and it's been the subject of a lot of comments. So it would be hard to say that, to actually say that that the applicant should have to prepare a supplement for something they already laid out, and that was subject to public comment. And I would say that the NRDC attorney was incorrect, because we both know that in the 624 regulations is a provision that says that the hearing record supplements the EIS. So that's just plainly wrong, what he said. There's also another case that follows Webster versus Webster Associates, that follows the same principle, that the failure to include a required item in a DEIS is not always fatal, and that's a matter of Caldor Corporation. It's a New York Law Journal case from 1995. It's a little bit hard to get, and staff would be happy to distribute it, but it sort of recites the same principle that yes, it is fatal in some cases, but it's not always fatal, because there are exceptions to that rule.
This is a Supreme Court.
This is a Supreme Court case, Justice D. Silverman. And I think both of those, both the Court of Appeals decision and Caldor sort of follow the department's sort of view of SECRA, that it has to be a little bit flexible, especially where you have cases like this that just go on for a very long time, and new alternatives pop up, and there's a lot of public controversy, and the lead agency has to have a little bit of flexibility. So here, yeah, the no action alternative wasn't explicitly discussed in the DEIS, but it has since been discussed.
How about alternative sites? Can you tell me why it is that wasn't required of this applicant?
Well, because...
Assuming that they actually own sites in the
okay,
area.
I wasn't...
Can I jump in for just a second? Mary, can I just interrupt? Because I can say something a little bit. I think the judge is asking about the Savona site. And I can say just a little something about it, because I've been working for the department for 25 years. I'm sorry. And I am familiar with the Savona site, and I was when I was assigned to this project in 2008 or 2009, whatever it was. And it's the same with Peter Briggs. He's familiar with the site. He was assigned from the beginning, and other staff working on it. We knew about the site, and we knew about how it worked and what its parameters were. And it doesn't have a salt plant, so the brine disposal there is limited. The caverns that are already there are some caverns that are storing gas, and some caverns that are being expanded in accordance with the department permit. And the brine disposal that results from that is going on under a speedy permit, but it's not that fast. And they don't have a salt plant, so we didn't see it as some kind of reasonable alternative. In fact, we saw that the salt plant at U.S. Salt was actually an advantage. The caverns already being done at the U.S. Salt site, so you don't even have to solution out the caverns or anything like that, so you don't have that kind of brine disposal. But there is a certain amount of brine disposal that comes at a place from precipitation, on the brine ponds, et cetera. So there's a little bit that's generated, and salt takes care of all of that.
I think the question here, though, is you're saying some alternative sites were considered.
I'm saying that
is that documented at all?
I'm saying that we didn't think it was reasonable to ask them to look at that, because we knew from the get-go that that was not A reasonable
The,
alternative.
the law is that they have, the law is that the agency has to look at reasonable alternatives. So what my colleague is saying, it was not considered a reasonable alternative at the time, so that's why it was not included. And I just want to add something because, you know, I've been with the department since 2007, and in the time I've been here, and I've worked on a lot of large projects, if not most of them, that the department receives, and we're always beating up on applicants to use existing sites. And that's for a good reason, because using existing sites has less environmental impact. So we have a project that came along here, and they're using an existing salt cavern. So that's like an environmental plus, rather than going out and creating something new or different. And that sort of fits sort of the policy of not stirring up, you know, green fields and ground that hasn't yet been stirred up. So it was reason. So this is a very reasonable site. And you know, there's a lot of bootstrapping going on here by Gas-Free Seneca. They keep talking about the truck traffic. I think my colleague pointed out that the truck traffic from the site is would add like 1 or 2% more to the existing truck traffic on the state highway. I think that's this discussion about truck traffic and its impacts has gone off the rails, to use a pun. And so it wouldn't be significant under any circumstance. I can't think of any project that would add 1 or 2% to an existing highway where the department staff would consider that a significant impact. Yes, the department staff does look at car and truck traffic where it might be a significant impact, like in the Bel Air case, where you were doubling the size of a state ski facility and adding a resort to an area that didn't have a large-scale resort. And Gas-Free mentions the Bel Air case and the noise study. Well, what they didn't mention was, in reciting to that case, which I'm very familiar with, is that project involved the development of a resort in the State Forest Preserve. And noise was a very big issue because of the presence of the State Forest Preserve and the construction of a wholly new resort on the side of a mountain there. And of course, that project has since changed. And
I'm aware of it.
And so it's not really a relevant comparison. How much time do I have left?
Minute 30 seconds.
Okay. Let's see if I... Just one other thing is that there is a discussion, but it's a programmatic discussion, of the no action alternative in the 1992 GEIS. So if you put that together with the letter from the applicant and the public comment together with that, I think we have a pretty good basis to evaluate the no action alternative, as with other alternatives. Thank you.
Thank you. So the Seneca Lake Pure Water Association has 60 minutes remaining.
Well, Mr. Alessi has given us a major reinterpretation of the DEC secret regulations, and he hasn't provided any examples for when this has been done. He is saying that the scoping process should require that the public provide alternatives and the consideration of alternatives, but the scoping regulations say that the primary goal of scoping is to focus the DSEIS on potential adverse impacts. So that's what the scoping process is about, is identifying potentially adverse impacts. And the EIS, it's a requirement of the EIS that the EIS analyze significant adverse impacts and evaluate all reasonable alternatives. The evaluation of reasonable alternatives is not part of the scoping process, but that's understood to be part of the EIS process. And he has not given any example of where an applicant has been able to avoid the consideration of alternatives by virtue of the scoping process. I think that Ms. Naismith gave an example of where a draft EIS has been required to be reissued, which is the hydrofracking situation.
Yeah, but the hydrofracking situation didn't go to an adjudicatory hearing.
Well, it didn't. And so that is a difference in this proceeding, but I think that it would, in this case, because of the significance of this issue, it might be the most efficient alternative to redo the EIS before going forward with the adjudicatory hearing, so that should precede a reissuance of the draft EIS.
So we could use our process to do that, right?
Yeah.
If to the extent that I or the commissioner think that further alternatives should be considered, then we could ask the applicant to provide those alternatives, and then we'd use the process to review that, get comments, and proceed. We could use our process to complete the record, couldn't we, on alternatives?
I think that's a possibility. I think that the better course of action would be to redo the full draft EIS.
And why is that? Well, if we're,
I think
we're supplementing the EIS
yeah,
here
yeah.
and subjecting it to our adjudicatory process, what would be better about simply doing a new draft EIS and having public comment on it?
Well, there are other issues that have been raised too. I mean, if that was the only defect in the...
Well, right, no, I'm talking about supplementing the secret record, which would include, as you're advocating, community character, alternatives, noise, et cetera. If it's included in here, all those issues need to be supplemented on this record before the commission can make a decision. Why would it be better to only have public comment as opposed to having a hearing process to do that supplementation?
Well, I guess I would hope that it might not be necessary to have the hearing, but I think the hearing process is an alternative, and would be a satisfactory alternative. It is established that the applicant does own other facilities, other storage facilities in this region. They did not identify those facilities in the draft EIS as other, in consideration of properties that are owned by the applicant. Those were not identified. Mr. Weintraub mentions the no action alternative was considered in this letter of 2012. I was not familiar with that letter, and I just reviewed the documents that are posted on the DEC website for this proceeding. There's section on positive declaration and scoping, and the letter's not under those documents. There's a section on DSEIS review and hearings, and that letter is not under those documents. I don't think that the public has been given adequate notice of that letter. Ms. Schwartz describes that the DEC did consider the Savona site. I don't understand why that consideration was not part of the EIS and the evaluation of that site. That is a site where brine is currently being disposed of. One issue regarding the disposal of brine, I don't understand why the TEPCO facility does not have a brine pond. I think it needs to be evaluated, the issue, when is a brine pond required, when is it not? It doesn't seem that all LPG facilities do have brine ponds. Mr. Weintraub said it's an environmental plus to reuse existing sites, but, and he points to the U.S. salt caverns. He did not address, again, the question as to why TEPCO moved out of those caverns, and what was the department's when the department evaluated the caverns for the applicant, what consideration was given to the circumstances that caused TEPCO to move. And I think that concludes my comments. Thank you.
All right, thank you.
And I'd like to give my excess rebuttal time to Ms. Naismith. If I have any.
No, I think.
Okay.
Thank you, I appreciate that.
I'm going to set this for 2.
Yes.
And maybe you can tell me why having a new draft ES and doing public comment is better than considering alternatives through the hearing process.
Well, we actually think, Your Honor, that both it would be an adequate solution. The problem with limiting ourselves here to just the hearing process is that while that's a great venue for developing what alternatives would be reasonable, which has not been done, and discussing those alternatives and elaborating on those alternatives, the limitation of adjudicatory hearing is the fact that the public is not going to have an opportunity to comment on that. It's limited. The comments that you would receive on those alternatives would be limited to the parties who are granted full and amicus party status.
Well, we would continue to receive comments. So if anybody wrote in about it, they would go into the secret record, I believe.
Well, as long as the full nature of the alternatives were in fact released to the public and that there was an opportunity for the public to comment and that was made clear to the public, because there's often confusion when there's a 30-day comment period. Not everyone appreciates that they can continue to supplement the record. As long as that was made clear, then that would potentially resolve the issue as long as there was a full discussion in the adjudicatory hearing. We think really that both could be done in this situation. I wanted to also just quickly, if I may, address the February 16th, 2012 letter. First of all, that letter is not really all that available to the public. It was accessible to us through a FOIL, but as you well know, I'm sure, Your Honor, that you have to know what you're foiling, and not everyone in the public is conscious of the fact that there was a letter submitted back in 2012 that they should be aware of. I also want to point out that the no action alternative discussion in that letter is inadequate. There are 2 sentences that actually go to the no action alternative. The remainder of the discussion is entirely about the purported benefits of the project. And if I may, basically all it says is, in this case, the no action alternative would see the continuation of activities on the U.S. Salts property at the, and I'm ellipses, at the surface facility site owned by Finger Lakes. There would be no activity at the site, though the surrounding properties would continue to be used for rail transportation, trucking, and perhaps solid waste storage. It's 2 sentences, and it was not released to the public in the way that SECRET contemplates. I'd also highlight that under Webster, the reason the court there found that the defect wasn't fatal was because it was clear from the record, and I'm quoting here, sorry, that both the general public and the relevant public officials were thoroughly familiar with this alternative. Although there have been discussions of alternative siting, nowhere did we discuss, and did the applicant discuss, the reasonable alternative that it raised in December about the alternatives with respect to transportation. We still don't really know what that's going to look like because it's unclear what the applicant intends to do. There's been no discussion of the relative impacts of that. With respect to the Savona site, Ms. Schwartz just provided us with a fairly good explanation of what they considered, but again, the fact that Ms. Schwartz can stand here and explain that to us is not the same thing as having that discussed to the public as part of the SECRET process. And what Ms. Schwartz is essentially engaged in there is an environmental balancing, not a discussion of what is feasible. And so that should have been part of the record. One final comment, if I may, as well, is that Mr. Alessi referred to the fact that there were past EISs done in this case. Those were generic EISs that were done 2 decades ago. They are not site-specific. They do not obviate the need to have a no-action alternative or a discussion of reasonable alternatives to this particular project, and nor does the scoping obviate, or any kind of scoping document obviate the ability or the requirement under the regulations to do a no-action alternative and to analyze reasonable alternatives to the project. You cannot scope out what is required under SECRET.
All right. Thank you.
Thank you, Your Honor.
And the Seneca Lake communities.
Your Honor, nobody is arguing that we need to freeze the process indefinitely, or even more absurdly, that there isn't an adjudicable issue here on on alternatives. This is absolutely a substantive and significant issue. But let's talk about Webster for a second. In Webster, the defect in the alternative discussion was not cured by an adjudication, which, having looked at Webster again, is not what happened there.
Right.
Instead,
it was cured by public debate. Isn't adjudication more robust than a public debate among officials? Our process is public.
It is more
There's
robust.
opportunity for parties like yourself to participate. The public can offer comments. I mean, is that better than a debate that happens somewhere out in the community?
Your Honor, it's different. I think the Webster case shows that. I mean, the primary reasons that the Webster case cited for this not being a fatal defect are that these two alternatives, both of which had been identified before the public started talking about them, were discussed in an election. They were discussed repeatedly in public meetings. What we have here is from the applicant literally zero citing alternatives. In Webster, we had two. Both of those alternatives were subject not just to fact-finding and a legal discussion.
We use the process to analyze and the other potential alternatives, use the hearing process to do that. Isn't that a public forum? Won't that be as good as a public debate?
We don't think so, Your Honor. It's necessarily limited to the parties that can make it to the adjudicatory hearing based on this issues conference. It doesn't involve the elected, it doesn't involve the general citizenry, which is what happened in Webster, and it's why it wasn't fatal in Webster. And that's what we think it would add. But this issue is still adjudicable. Now, there are two other points very quickly. The applicant is mischaracterizing the project's needs and objectives. Just take a look at their DSEIS. Nowhere in their submissions do they say that the focus or the purpose of this project is Seneca Lake, the Finger Lakes, and certainly not these caverns specifically. This is about the Northeast region, both in their description of the need and the benefits. They're also suggesting that because they've provided no alternative sites, it is the petitioner's responsibility to show potential alternatives. That's not the way this works. The petitioners have no reasonable way of determining the alternatives that are available to the applicant, because many of those questions not only depend on the sites that they own and could option and that their parent company own and could option, but also on the technical specifications of those sites, facts known only really to the department and to the applicants. And again, the alternative sites need to be evaluated given the focus of this project, which is this region as a whole. Thank you, Your Honor.
Thank you. All right, so the next issue is cumulative impacts. Do we want to take a break at this point?
Yes.
It's been almost 2 hours. Would 10 minutes be sufficient? All right. We are adjourned.